The first case is the Ibanez case, which is a Massachusetts Supreme Court case that was adjudicated this year. The case started in the lower court through the appeal court all the way to the Supreme Court. On page 8 of the judge's decision, the following language is very, very damning for the mortgage and securitization industry. The judge's decision said, and I quote, "To foreclose on the mortgage securing property in the Commonwealth, one must be the original holder of the mortgage. To be the holder of the mortgage, one must be the original mortgagee or is the assignee under a valid assignment of the mortgage. It's not sufficient to possess the mortgager's promissory note." The court correctly held that the plaintiffs, U.S. Bank and Wells Fargo, were not the holders of the Ibanez mortgage and at the time of the foreclosure, because they were not the assignees of a valid assignment of the mortgage. Without valid assignment, the plaintiffs lacked the legal authority to foreclose on the mortgages. This was sufficient grounds on which to invalidate the foreclosures. So this is actually a situation in which homeowners who were foreclosed on were able to reverse those foreclosures because they were able to show that the plaintiff, those foreclosing parties, lacked sufficient standings. In other words, they did not have enough valid possession of the note. And this has sent a wave throughout the country, citing the Ibanez case as the precedent. Another case that is very telling about the status about this type of litigation just took place in Russell County, Alabama. This is the Horace versus LaSalle case. Again, what we have here is somebody who challenged the bank's right to foreclose based on chain of assignment. This is some incredible language within this case. And the plaintiff, the homeowner, actually won a motion for summary judgment. This is the actual language from the judge's order. First, the court is surprised to the point of astonishment that the defendant, trust, LaSalle Bank National Association, did not comply with the terms of its own pooling and servicing agreement, and further did not comply with the New York law in attempting to obtain assignment of plaintiff Horace's note and mortgage. Consequently, plaintiff's motion for summary judgment is granted to the extent that defendant trust, LaSalle Bank National Association, is permanently enjoined from foreclosing on the property known as 3745 Knowles Road in Phoenix City, Alabama. Now, what the judge said is, you don't have the right to foreclose. Not only that, we don't think you will ever have the right to foreclose. Therefore, we will permanently prohibit foreclosing on this property. Now, keep in mind, there is somebody who is a valid holder of that note, and I believe that entity is called Encore Credit Corporation. However, Encore sold that mortgage and received funds against it. The likelihood of them coming over now to foreclose is now much lower. This presents a really significant problem for banks like LaSalle, who are unable to prove that they have valid ownership of the note. LaSalle Bank cannot prove that they have ownership of the note. This was an actual statement from the plaintiff's attorney, and again the judge ordered favorably based on this motion. So, let's get through this. We now know that the lender does not have the right to foreclose because of how New York trust law is worded and because this note was not validly transferred into the trust. We also know that the trust was closed after a specific cutoff day and is now closed, so they're not allowed to take additional notes. So if it was not originally put into the trust through the transfer and the trust is now closed, it could never have went into that trust because it was too late. Yet the note still made it in the trust even though their own pooling and servicing agreement specifically indicated a designated cutoff date. How in the world can they be allowed to breach their own contract that they wrote? This is very, very powerful stuff. You've probably seen some of this stuff in the press. I want to share a couple recent press articles that I think tell a story of where things are headed. 60 Minutes did a great piece on April 3rd. To summarize this statement is made, it's bizarre. It turns out Wall Street cut corners when it created those mortgage investments. That triggered the financial collapse. Now the banks want to evict people. They're unwinding these exotic investments to find that often the legal documents behind the mortgages aren't there. They're caught in the jam of their own making. These appear to be resorted in forgery and phony paperwork to throw people down on their luck and out of their homes. Now, listen to this very carefully. The Palm Beach Post on April 1st did a review of cases at the state and appeal courts and found judges are routinely dismissing cases for questionable paperwork. Although in most cases, the bank is allowed to refile the case with the appropriate documents, in a number of growing cases, judges are awarding homeowners their homes free and clear after finding the fraud upon the court. Ladies and gentlemen, this is happening all across the country right now. However, Is it the norm when you litigate against your lender and when you seek this type of outcome that you actually get your home free and clear? Of course not. And that's not what most people want. They just want fair treatment from the lender. The way to do that is to step up and demand fair treatment. Now, perhaps the only thing more important than what you see in the courtroom during the press comes from the horse's mouth. In Bank of America's 10-K filing last year, they stated, many derivative instruments are individually negotiated and non-standardized. This can make exiting, transferring, or selling some positions difficult. Many derivatives require that we deliver to the counterparty the underlying security loan or other obligation. This could cause us to forfeit the payments due to us under these contracts or result in settlement delays with the attendant credit operational risk as increased cost to us. Wait a second now. Did Bank of America really just say that? Did they actually just say that they don't have the note and may not have the right to collect payments? You betcha. You heard it right from the horse's mouth. This does not put Bank of America on very good legal ground. And, in Bank of America's own words, you may have the upper hand. All you have to do is get the paperwork. Now, let's take a look at MERS. MERS, in an announcement to their own members, stated, MERS is providing the following guidance to all members to strengthen business practices and minimize reputation. Legal and compliance risks to MERS and its members. In recent months, legal challenges have risen regarding alleged inadequacies and improper proceeding in the foreclosure process, including allegations of insufficient or incorrect supporting documentation and challenges to the legal capacity of the party's right to foreclose. MERS goes on to say, MERS is planning to shortly announce a proposed amendment to membership rule, and the proposal amendment will require members to not foreclose in MERS' name. We encourage members to bring foreclosures only in the name of the holder of the note, in the name of the trustee or the servicer of the record acting on behalf of the trustee. Guys, these are internal admissions that the company has not been following the appropriate protocol, and they've recognized the need for change. You know, in some circles, they would call this an admission of guilt. Sheila Bair, chairman of the FDIC, said this problem was pervasive. On 60 Minutes, she actually recommended that the banks set aside billions of dollars and propose that these funds be used to pay homeowners to accept banks' ownership claims without making them produce ownership of the documents. Are you a victim of these abuses? Who really does own your mortgage note? Does your lender have the right to foreclose? Or for that matter, do they even have the right to collect payments from you? Do you want to level the playing field? And do you want to put your lender in the hot seat? For many homeowners, the answer is yes. Absolutely yes. So now, what do? If you're going to do anything, make sure you do these two things. Order a securitization audit and find out whether or not your lender actually has the right to collect payments from you, let alone try to foreclose on a debt they have no rights to. Again, a securitization audit is not litigation, but it is a very important tool in building a case against your lender. This leads us to your second option. Number 2, talk to an experienced attorney about your litigation options after you get a copy of your securitization audit. This has been a presentation by Property Solutions Center. Thank you very much for watching. If you would like more information, please visit us at www.propertysolutioncenter.com. Again, that website is www.propertysolutions.center.com.